I'll try to be not as boring as legal sometimes sound. So also, sorry, part of the presentation will be in this slide because I changed slightly what I was going to talk based on what I was talking to everyone here and what seemed to be a bit more of interest. So once we're talking about how Web3 is disrupting the legal system and how all of this would affect us, is a bit of how any new technology would affect us. Not any, but in this case, we're talking Web3, and how the legal system would react to that. So bringing a few of the examples that we are currently seeing, it's a bit of a race between the market, the community pressure, and the regulators itself, because the regulators want to go after the money and where the money is. The community is trying to avoid really tight regulations. So if you anticipate so much the regulation, or if you regulate too tightly places that don't need yet to be regulated, you will kill the market that was supposed to be growing at this space. So people will migrate. Most of the projects today, they are not tamed to a specific place. You cannot chain them to the ground and say, you're not leaving my country. So if you squeeze them too tight, they will just find new regulators. They will find new jurisdictions that will be more favorable for them at that stage. So a bit on this kind of race between regulators and markets, we saw in the last year more, the regulators trying to rush it. So they were trying to regulate whatever was in trend in the Web3 space. So they're listing a bit of trendy words and going like, okay, the money's there, the trend is there, let's try to regulate this. And then by trying to rush this, we got now a bit of Frankenstein regulations all around, or regulations that are pretty much old regulations with a bit of glitter on it, saying, look, this is a new thing. That happens a lot with DAOs, for example. We have a lot of DAO regulation, not a lot, but a few of DAO regulations going around that if you look tightly to it, they are nothing more than a normal LLC regulation saying DAO in the end. What do you gain with that? Some legitimacy with the market, some companies being trendy and having a DAO, but the ultimate point of it, or the ultimate point of you having a DAO, will not be accomplished. That would not be totally decentralized. So you offer, in the hand, a bit of protection. In the other hand, you take a bit of what the market was really craving and what we were really wanting as regulation. And then we have other aspects of it. For example, MiCA. MiCA is a big trend. Everyone has been asking me about MiCA in this last day and today. Like, what do you think about MiCA? Does MiCA solve our problems? Of course not. MiCA was a great first step, to be very fair. I have lots of colleagues that are not really big fans of MiCA. I have colleagues that love it. I'm a bit in the middle ground of it because I think MiCA was actually great to give us the lay of the land, to give us basic concept, to give Europe a first step. So every other regulator in Europe could be working with the same basis. So we all know the same concept. So whenever a country in the European Union start regulating something, we all know what they're talking about. Like, we have the concept, so we can always go back and forth. So it is a great base, but it's not enough. And then in the other side is, like, MiCA did not regulate DAOs. I just heard this in the panel downstairs, re-hearing it, and was good because, indeed, yeah, why? And then we get as ourselves things like, why didn't they regulate DAOs? In the hand, we know people that are talking to the regulator, and they're saying it's not the moment yet. So MiCA have been postponed for months and months. Do we want to postpone it again to regulate something that is growing? Like, what the regulation aims. Because for you to regulate something, and then honestly, regulating just to regulate something never worked in history. So do we want to regulate just to regulate, or no? So we have to educate also the legislator. And by doing that, we have to show them what are the potential problems, and then try to tackle the problems, not just throw random regulations through just because. So once we identify the problems, then we can move indeed to regulate. But that's a step-by-step that always is a process. Another topic on this disrupting of the legal system on Web3, and have been a great topic all around, have been tokenization, especially of real estate, it's great. In a lot of countries, we can actually, at some point, do it. But why does this have to do, especially with disrupting? Because, for example, as much as we have mechanisms to go around and tokenize a lot of assets, especially real estate, the registries itself, the real estate registries of special countries, they're not equipped for it. So most countries don't recognize crypto as legal tender, and that's a fact. So I cannot go to a registry and say I bought an apartment for whatever number of Bitcoins. They will say, okay, what's the equivalent on dollars? And I'll have to put there. Okay, you cannot have, in most countries, your registration in real estate without having a fiscal number. So all of this have to change. We have to start challenging the internal regulators by each country and then having all of this on base. And that's not mine. Sorry, guys. I think we can go. So, and then now going a bit back on, okay, let's go for the first impacts of that the legal system faced once we are talking Web3. That all started with smart contracts. Smart contracts, as we all know, everything is on the code. And then once the conditions in the code are met, it's executed. You don't need a third party to go there and activate or do anything for that to be executed. Very much not unlike the traditional legal system where you have papers, you have contracts, you have true registry. Why is that important? That was a big step towards, first, transparency and efficacy of the legal system itself. But also that brought a whole new novelty of problems that we were ill-equipped or we were not prepared to do it, like code errors. I mean, I don't know any regulator that really understands the coding, so once you have the problem with the smart contract, what do? We are ill-equipped to do that. So this is something that we have to constantly be doing. We're still not equipped to do that. But the community itself is starting to find different solutions. And then a few of those solutions, those are just examples. We have Arbitrum and Claros. What are those platforms? They're pretty much proposing themselves to be decentralized courts, let's say it like that. And their main focus ends up being DAOs and smart contracts. What they're trying to do, they're trying to solve disputes that might arise from specifically DAOs and smart contracts in this case, to achieve a resolution, to resolve this dispute through consensus. What does this matter? This was for sure expedite a lot of the process and would be way more cost efficient than traditional courts. What's the downside of this? Those are pioneer projects, those are novelty projects. So we still don't have much concrete cases, and we still haven't faced the problems. We don't know what are the concept of this concept of fairness. We don't know how through they are with the processes, and that brings a bit of uncertainty to us. But on the other hand, do we really want to replicate the legal system that we have, let's say, in the real world to the Web3 community? Do we want to have disrupting? Do we want those kind of decentralized justice courts to follow completely different rules, a bit of different rules? Do we want to have a hybrid, so pick the best that we see in the legal system and bring it there? So all of this is still very much under discussion, and we don't have the answers to it, unfortunately. But they're there. So the community itself is trying to also bring solutions. We are not just actively complaining or talking to the regulators or something like that. We are starting to see actually projects and actions being taken there. And that brings us to a bit of regulatory changes. What are those in this sense? So once we're talking about a world that is, let's say, a lot of cross-border operations, or even more, borderless operations, what does that mean? It's like, what jurisdiction is going to be the one responsible for that? What laws do we apply? Those are constant questions of the whole community. And then we'll depend on case by case, on the sense that, okay, my project's anywhere, who should regulate? We actually, that goes, sorry to repeat, but it's like a lot case by case, and I know it's annoying to hear that about a project. Whenever you consult someone, you're like, yeah, I have to see your specific case. But And then that brings even more problems, not problems, but challenges on the sense that we are dealing a lot now with anonymous or pseudonymous persons. So how we reach those people, it's possible to reach it. Do we actually want to reach it? So it's a lot of construction there. And on top of that, we have a bunch of other problems like, where is the IP rights on a decentralized world? Is there any IP rights? Everything is open source, is not. If it's in decentralized, what IP legislation are we going to put? Do we actually want to protect it? So questions are arising each day more, and we have then to work to bring those answers. And then again, it's the balance that I was saying in the beginning between not rushing the legislation, but being somewhat ready when the problems start to arise. We don't want that to be Wild West, but we don't want to be ultra-regulated market again. We already have an ultra-regulated market, but we also saw in the other side of the coin that a totally unregulated market is not good for the consumers. I mean, a lot of people already lost a lot of money because of a lack of regulation. We don't really want that. So finding this balance, it's kind of hard, but it's not unachievable. And then we comes ourselves to a legal system adaptation. So I brought how it does because it's vastly known as the US criteria that the SEC used to see investment contracts, most known as securities. This is how those questions being answered, is how the SEC currently see if something is a security or not. Why the US itself? It's important because it brings up a wave. A lot of countries followed how it tests because of the US, and a lot of countries look to the SEC as, well, source of inspiration for this kind of regulation. But we have to keep in mind that how it tests was not built for Web3. How it tests was built for financial and traditional banking systems, and it worked for years. It's not something new that it was invented now for Web3. No. Have been in place for years and have worked for years because it was built for that kind of community. What is happening now is SEC specifically, and then the regulators that follow SEC, they don't really know how to act when they see a Web3 kind of security because a lot of them have loopholes and the 4 criteria are not met. And for you to be a security, the criteria have to be met. So they started also. The community was inventive to go around the Howey test, and the SEC was twice as invented, and then they decided everything is security. So they started this little crusade that everyone is saying that is going around, and we don't really want that. So the legal system have to adapt. We saw Howey test is not effective, so instead of trying to enforce to everyone, why not create a new criteria? Why not put out there a criteria that would actually work for us, that would actually come to this middle ground that, okay, it's effective? Because, I mean, everyone here already saw projects that are clearly securities, but don't meet the criteria, so they are out there, and they're not regulated. And the other way around, projects that are clearly not a security, and they somewhat got regulated. It's like, why do we have projects like this? This is not good for us. This is not good for the community. So we have to start adapting the legal system. If we're not able to create, let's adapt to what we have. We have to find this middle ground. And then, yeah, to conclude a bit is exactly like Web3 comes with a lot of challenges, brings us a lot of opportunity, but with that, it creates a very much more transparent, efficient, and accessible legal system. Legal, it's not really easy. Legal tends to be a lot the blocker for a lot of projects. I know how much, especially the project manager guys, hate sending products to legal and being sent back. But it is important. We have seen that more and more projects, especially the legit ones, are trying to get themselves regulated. They're trying to be in the good side, especially investors. Investors have more and more went to the, I mean, Web3 is never really safe, but towards the safer side of the operations instead of going so much rogue. And the whole concept of total decentralization of justice, I don't think is impossible. I think it's a project ongoing. We're somewhat getting there, baby steps. I don't think also it's impossible to reach some of it a day, but also our concept of justice and legal system will have to change if we're going to achieve any of that. So yeah, that's it for me for today. thank you all for being here.